Good day, whatever time of day it is where you are, to you, ladies and gentlemen. This is Criminal Law, CRJS312. I'm now going to be lecturing on Chapter 6 from Contemporary Criminal Law by Matthew Lipman. I'm going to be talking from my outline is based on the second edition, but of course the fifth edition is the newest book, which is technically required for the course. But I just use this because I've already outlined it, and that's what I teach from. But I cross reference it to the other chapter, to the other books, the later edition of the book. So it is legit. Without further ado, Chapter 6 is parties to crime and vicarious liability. Now, parties to crime, or what we call complicity. That means, everyone who's complicit or within or in on the crime. Individuals who assist the perpetrator of a crime before, during, or following the crime are all held criminally liable. Now, they're held criminally liable or responsible, but they're held criminally liable or responsible in differing degrees depending on what their involvement is. So we're going to talk about that. Individuals who assist in the commission of a crime are held liable for the criminal conduct of the perpetrator of the offense. Now, at common law, the old school law, we had two different categories of accomplices or parties to a crime. You had principals. Principals were those who are present and actually carried out the crime. Principals in the first degree would be the actual perpetrator of the crime. Principals in the second degree are individuals assisting the principal in the first that are actually either physically present at the scene or constructively present, meaning that they directly assist the crime at a distance by acting as a lookout. So you had principals, and that includes principals in the first degree and second degree. And then you had accessories. Accessories are those who assist principals. An accessory before the act is individuals who help to prepare for the crime. This includes those that provide weapons or instruments to commit the crime. To commit the crime or help plan it. An accessory after the fact are individuals who assist the perpetrators knowing that a crime has been committed. This includes those who help principals escape or hide evidence. Under common law, principals and accessories were both punished the same. Principals and accessories could be prosecuted only following the conviction of the principal in the first degree. So this meant that if the principal in the first degree was not convicted, everyone else's case was dismissed. So in other words, since they couldn't prove the crime took place from the principal of the first degree, it meant everyone else was also not guilty. This posed a barrier to prosecution in those instances in which the principal in the first degree was acquitted, fled, or died, or in which the principal's conviction was reversed. Modern law, that was common law we just talked about. So that's to give you a history, a background. And modern law, we have two parties to crime, and the first is accomplices. Those are individuals involved before and during the crime. This includes the perpetrator and the individuals planning and organizing the crime, as well as the lookout, the driver of the getaway car, and the individuals disabling security officers or alarms. They will be charged with the actual crime and will receive the same sentence as the perpetrator if convicted. So that's accomplices. At common law, we have accomplices and accessories. Next is accessories, and we call them accessories after the fact or / after the fact. Individuals involved in assisting an offender following the crime. Accessoryship is no longer viewed as being connected to the central crime. It is considered a separate, more minor offense involving the frustration of the criminal process. In other words, it's more of an obstruction of justice situation. This person is charged as a lower level felony or misdemeanor. So they're charged a step or two under the accomplices. Um, Derivative liability. The accessory's guilt flows from the acts of the primary perpetrator of the crime. There's a presumption that the individuals who assisted the offender implicitly consented to be bound by the conduct of the offender. They forfeited their personal identity. So that means essentially everybody's a part of the crime, just at different levels. Then we have conspiracy, and we'll talk more about conspiracy in a future chapter. Conspiracy is nothing more than an agreement between two or more people to commit a crime. The Pinkerton rule of conspiracy. A conspiracy to commit a crime and the crime itself are separate, distinct crimes, and an individual may be charged with one or both of these offenses. So it's the crime and the conspiracy to commit the crime. They're separate, so you can be charged. A person can be charged with both. Now, what is the actus reus of accomplice liability? So, what to be an accomplice, or even an accessory? What is what acts do you have to take to qualify to be one of these? Statutes and judicial decisions describe the actus reus for accomplice liability using a range of confusing terms like aid, abet, encourage, and command, satisfied by even a relatively insignificant degree of material or psychological assistance. There's no requirement that the prosecution demonstrate that the accomplice's contribution was essential to the commission of the crime. So it doesn't even matter that whatever help the accomplice tried to give didn't even matter or didn't have any bearings on whether the crime was committed. It's just that they did it or they tried to, that they rendered aid. This is intended to deter individuals from assisting in the commission of a crime. A defendant who offered to make an automobile available was guilty of being an accomplice to murder, despite the fact that the perpetrator carried out the crime without the car. Seems a little bit unfair, but I see why they want to deter people from having anything to do with the commission of a crime. And remember, we talked about deterrence. So that'll deter people in the future from having anything to do with the commission of a crime, right? As long as the individual acts with the required intent, he or she will be culpable as an accessory. That means the required intent or the mens rea is essentially the intent that the crime be committed or completed. So you're helping or you're an accomplice and you want the crime to either be completed or you know that the crime is completed and you want to assist in helping hide evidence. You want to assist in either hiding evidence or obstructing justice. Okay, then we have the mere presence rule. Being present and watching the commission of a crime is not sufficient to satisfy the actus reus requirement of accomplice liability. So just because you're there, and even if you didn't necessarily do the right thing, if you're there, that doesn't make you an accomplice. Here we have a case. Bailey v. United States. Bailey spent most of the day conversing with his partner and then left to shoot craps while his partner stood across the street near the entrance to the market. Bailey later joined his partner. The two watched as an employee followed his regular routine and exited the market carrying money in a bag. As the employee approached, Bailey retreated to the curb 10 feet from his partner, who then seized the money at gunpoint. Bailey and his partner fled, and only Bailey was subsequently apprehended. The Court of Appeals determined that Bailey was innocently talking to his partner when his partner suddenly pulled out a gun and seized the bag of money. The fact that Bailey fled did not mean that he was involved with his partner in either planning or in assisting the crime as a lookout. Individuals who were entirely innocent sometimes flee based on fear of being considered guilty or in order to avoid appearing as a witness. So just because I'm standing beside somebody and I'm present and we're sitting there talking and they decide to commit a crime while we're standing there and I see him do it and I run away, even if I'm running with them or in the same direction as them, that doesn't mean I had anything to do with the planning or being an accomplice after the fact to the crime. It just means I don't want to be there because this guy just committed a crime. So that's essentially what the court said in the Bailey case. Then we have State v. Walden. This is an exception to the mere presence rule. So we get the Bailey versus United States case is nothing more than an application of the mere presence rule. Um, State v. Walden is an exception to the mere presence rule. A mother was convicted of aiding and abetting an assault with a deadly weapon when she failed to intervene to prevent an acquaintance from brutally beating her young son. Why is this an exception, you say? Because as a mother, remember we talked in early chapters about people having the duty to intervene because of their relationship to whoever they're, have a duty to. Of course, the person has a duty to intervene. So that the exception to the mere presence rule is when a person has a duty to intervene. A parent's failure, and the case says a parent's failure to protect his or her child communicates an approval of criminal conduct. So the mother was merely present and may not have known about the crime that was about to take place against her own child, but when it happened, because of her relationship as the parent, she had a duty to intervene to try to stop it. And her failure to do so essentially made her an accomplice to the crime that had taken place. So there we go. I knew I was missing something. Okay. It probably sounds better. All right. Now where was I at? Okay. Then we have State v. Olviven. Make sure this is the right case. State v. Olviven, where a mother-in-law is downstairs asleep while her son kills his wife. After the murder, the mother-in-law keeps the children out of the bedroom as her son dismembers his wife's body, and she helps to conceal the crime after it happens. Olviven, the mother-in-law, was convicted of murder as an accomplice. On appeal, the conviction was reversed. The defendant was present when the murder took place, but she was asleep and took no active part in the murder. The use of terms such as aids, advises, and conspires requires something more of a person than just mere inaction to impose liability as an accomplice. Now, we talked, that's the actus reus, that you have to do more than just be merely present. You have to take some act in furtherance of helping the crime take place, even if what you do doesn't help the crime take place. Some action or some assistance in trying to help the crime along, or helping the people get away from the crime after the crime has taken place is what's needed. So it's not just being present. You have to do more. Unless you have a duty. Remember, the duty to act is the exception to the mere presence rule. So now that's the actus reus. Now we're going to talk about the mens rea, the mental state that's required for you to be have accomplice liability. A conviction for accomplice liability requires that a defendant both assist and intend to assist the commission of a crime. Now we're talking about accomplices. Now remember, there's accomplices, and then the accomplices, and then what's that? Not principles, but accomplices and accessories. So one must have the intent to assist the primary party and the intent that the primary party commit the offense. So that's the two parts of the mens rea. There's an intent to assist, so that means you know that a crime is going to happen. You want it to happen, and there's an intent that they actually commit the offense. So you're purposely assisting them, and you want them to, and you intend that they commit the offense. Mere knowledge was not sufficient to hold a person liable for aiding and abetting.
So just because I know the crime is taking place doesn't mean I am an accomplice. I have to actually take some steps in assisting and intending to assist, and I have to do so with the intent that the primary party actually commit the crime. There is a requirement that the defendant associate his or herself with the venture, that he or she participate in it as something that he or she wishes to bring about, that he or she seek by his or her action to make it succeed. So just knowing that something is happening or likely to happen doesn't make you an accomplice to a crime. There must be a propulsive attitude. In other words, you want it to happen. There's a purpose. There's purposeful attitude and purposeful action, not just knowing. An individual will not be held liable as an accomplice for knowingly rather than purposely aiding the commission of a crime. So it has to be more. So in other words, it has to be done with a purpose that the crime be committed. Some jurisdictions have ruled that the mens rea requirement for accomplice liability in crimes is satisfied by knowledge of a defendant's criminal plan. So that's some jurisdictions. Example: a seller may not ignore the purpose for which the purchase is made if he is advised of that purchase, or wash his hands of the aid that he has given the perpetrator by the plea that he has merely made a sale of merchandise. So in other words, if I sell a gun in this situation, in this type of jurisdiction, if I sell a gun to a person that says I'm going to go kill somebody with it, then I can't now say, well, it was just a good faith purchase. In that situation, that is the mens rea. So it's not just knowing, but well, in that situation, knowing is enough. Helping a person or aiding in the crime and knowing, not just actually doing it with the intent that the crime be committed. Knowing is enough in certain jurisdictions. And that goes to show that in some jurisdictions there kind of wrinkles in it. But the primary jurisdictional approach is that it must be done not just knowingly, but with a purpose. So of course, to do something on purpose, you know about it, but there's a purpose that the crime be completed. So you're doing it to assist in the crime, and there's for the purpose of the completion of the crime. Regardless of whether it is a purposive or a knowledge standard, an accomplice is subject to the natural and probable consequences of what we call the natural. Well, let me read it over again. Regardless of whether it is a purposive or knowledge standard is employed, an accomplice is subject to the natural and probable consequences of the doctrine. Or the natural probable consequences doctrine. I'm sorry. Natural and probable consequences doctrine provides that a person encouraging or facilitating the commission of a crime will be held liable as an accomplice for the crime he or she aided and abetted, as well as for crimes that are the natural and probable outcome of the criminal conduct. That's all that means. So, complicity in the book, and at least in the second edition, they have these equations. Complicity or accomplice liability is completed when one aids, assists, incites, counsels, encourages another to commit a crime, or failure to fulfill a legal duty to intervene, plus is done with a purpose to encourage or assist another to commit a crime. And it's with the intent that the crime actually be committed. So we have a case, United States v. Fountain. A three-time jail shanker / murderer is being escorted from solitary confinement when he reaches his hands into another cell where another inmate unlocks his cuffs and makes a shank available by lifting his own shirt where he has a shank concealed in his waistband. The murderer takes the shank and goes to work on one of the guards and kills him. The accomplice conviction of murder was affirmed. The court held that aiding and abetting murder is established by proof beyond a reasonable doubt that the supplier of the murder weapon knew the purpose for which it would be used. The accomplice must have known through discussion that the murderer had already killed 3 people in prison. This is the foundation of an inference that the accomplice knew that the killer wanted the shank in order to kill someone. This is an application of the natural and probable consequences doctrine. So that means that accomplice is now liable for the natural and probable consequence. So it was probable that this guy who had committed 3 murders while in jail would do it again if you provided him with the shank, and he provided him with the shank. Then we have State v. Linscott, where someone is killed in an armed robbery. The murder of the victim is a natural and probable consequence of the intended robbery because of the dangerous nature of an armed robbery. The accomplice conviction for murder was upheld where he was an accomplice of a robbery where his partner killed the victim. And that's also a part of when we get to conspiracies, we'll talk about stuff like that as well. So now we're going to talk about accessory after the fact. At common law, a conviction of accessory after the fact required that a defendant conceal or assist an individual whom he or she knew had committed a felony in order to hinder the perpetrator's arrest, prosecution, or conviction. They were treated as accomplices and were subject to the same punishment as the principal who committed the offense. So, wow, that was pretty harsh. A wife, however, could not be held liable as an accessory after the fact because it is expected that she assisted her husband. And at common law, you're going to see a lot of this archaic treatment of women as kind of property of their husband. So if their husband committed a crime, she's not going to be held liable as an accomplice because, or an accessory at least, because she's supposed to assist her husband. Now, what are the elements of accessory after the fact? First, there must be the commission of a felony or commission of a crime. There must be a completed crime. The crime need not have been detected or formal charges filed. It just has to have a crime has to have taken place. Then 2, knowledge. So that's the mens rea. So with accessory after the fact, in order to help someone after they've committed a crime, the first thing you have to do is know that they've committed a crime. A crime must have been committed. Then the alleged accessory must know. So the defendant must possess knowledge that the individual whom he or she is assisting has committed the crime. A reasonable but mistaken belief does not create liability. So not knowing, but being mistaken that the person has not committed a crime, exonerates a person. So you have to know. So if it's a mistake, but you don't know, you're not going to be held criminally liable as an accessory after the fact. So the actus reus is an affirmative act. So there's the commission of a felony. After the commission of a felony, that the accessory must have knowledge that the person has committed the felony, and then they must take an affirmative act. The accessory must take affirmative steps to hinder the perpetrator's arrest, or what do we call it? Obstruct justice, in other words. A refusal or failure to report the crime or to provide information to the authorities is not sufficient. So just because you don't want to be a snitch, not being a snitch does not make you an accessory after the fact. You can know something, you can know a crime is taking place and then refuse to tell anybody about it. But if you didn't do any affirmative act in helping them get away, then you're not an accessory after the fact. You're someone that knows what happens and refuses to tell, but you're not an accessory to the crime. An example of an affirmative act would be hiding or helping a felon escape, destroying evidence, or providing false information to the police in order to mislead law enforcement officials. So there's a difference between not saying anything and then saying something that's meant to deter, or what would I say? Not deter, but misdirect the officers from finding out what the truth is. So in other words, that counts as an affirmative act. So if you know a crime's taking place, but you don't affirmatively act, but you know and don't tell, you're not an accessory. But if you know a crime is taking place and then you give the officers false information to get them off the trail of the principal or the accomplice, then that is an affirmative act. That counts as an affirmative act. What is the intent or the mens rea? The defendant must provide assistance with the intent or purpose of hindering the detection, apprehension, prosecution, conviction, or punishment of an individual receiving assistance. So there's kind of two mens reas. The first mens rea is that they must know. They must have a knowledge that the crime is taking place. And once they have the knowledge that the crime is taking place, they must take an affirmative act to help the person get away or to obstruct justice, and with the intent that the person actually obstruct justice. So with the intent that the person gets away or isn't arrested or evidence is hidden. So that there's a knowing, and then after the knowing, there's an intent to hide or obstruct justice. So there's two levels of intent. Okay, the modern view is that because accessories after the fact are involved following the completion of the crime, they should not be treated as harshly as the perpetrator of the crime or accomplices. They're now held liable for a separate, less serious felony or misdemeanor. Most states have abandoned the common law requirements that frustrated the conviction. What that means is now, back in the day, if the principals or the accomplices weren't convicted, that means the accessories also couldn't be convicted. So the case would have to be dismissed. In modern law, they no longer have that. So it's no more spousal immunity. So a spouse can't, for one, a wife can be an accessory after the fact. And there's also no requirement that an individual may be prosecuted only as an accessory after the fact, only after the conviction of a principal. So they don't have to convict the principal or accomplice first before they can prosecute. So most states only require proof of a completed felony. All right. Got another case, State v. Chisholm. A cross-dresser gives his uncle a ride to his wife's house, where the uncle kills his wife directly outside of the vehicle after an argument. The cross-dresser witnessed the shooting. Directly after the uncle pushes the victim into the car, the cross-dresser drives off with the uncle and the victim in the car and drops him off on the side of the highway. The cross-dresser went home and didn't tell the authorities until the next day after he was coerced by his mother. The jury convicted him of accessory after the fact to murder, and his conviction was actually upheld. So essentially, he didn't know that he knew the crime had taken place because the person had killed the person right there in front of him, and then the person pushed him in the car, and at that point, he drove off and dropped him off and didn't say anything. Well, so essentially, he kind of was obstructing justice because he was helping his uncle get away. So that's why he was held liable or found guilty. Now, let's move on to what we call from accomplice liability to what we call vicarious liability. Vicarious, just like you said, when you live vicariously through someone, you're living through someone else's eyes or shoes. You're kind of experiencing their life by watching them. That's kind of what that should give you an idea of what vicarious liability means. It imposes liability on an individual for the criminal act committed by another. Individuals may be held liable based on their relationship with the perpetrator of a crime. This is distinguished from strict liability. So I know you're hearing the word liability a lot. There's accomplice liability, which is someone being held. Everyone is part of a crime. How they fit into the crime and how they're going to be punished as an accomplice or an accessory. Then there's strict liability, and that's a type of offense where just because it happened, there doesn't need to be an intent, a mens rea. So I don't want you to know the difference. And then, strict liability is when the crime doesn't require mens rea because the act itself is prohibited, and vicarious liability is different from that. It is when an individual is held liable for the actions of another because of their relationship to the actor. Due to the public policy of the protection of the public, strict liability and vicarious liability can be applied at the same time. That means someone can be someone can be in trouble for the act committed by another person, and the act that person committed was an act that does not require mens rea. So I just don't want you to get mixed up because of the word liability in these cases. Just know there's a difference between strict, vicarious, and accomplice and liability. All of them are different. Now, vicarious liability, the equation that the book has, is voluntary act or omission or possession by another, plus the status of employer or parent or owner of automobile. So essentially what it means is if you have some type of relationship to someone as their employer or contractual, or you let them use your car, or you're their parent, and something happens while they're in one of those positions, while you're in that position, you can be held criminally responsible for their actions. An example, it would be extending guilt to an employer for the acts of an employee or imposing liability on a corporation for the acts of a manager or employee. That's an example. The purpose of this is to encourage employers or people in control in general of other people, and to monitor employees as to ensure that the public is protected from potential dangers such as poison food. So normally when we talk about vicarious liability, we're usually talking about corporate settings, but it can, like I said, it can be applied in parental settings. Normally, of course, corporations can be held liable for crime, but you can't arrest a corporation. It's a business entity. It's not a person. But a corporation can be penalized. A corporation can be penalized, especially monetarily, and be sanctioned because of the actions of its officers or employees. The public policy to encourage corporate executives to vigorously prevent and punish illegal activity. A corporation is a legal person. So as a corporate entity, they are counted as a person. You just can't how do you take a corporation and sentence them to jail? You can't do that. Now, of course, members of the corporation who partake in certain crime, they can individually be charged as themselves, and as well as the corporation be charged separately. But as individuals, they can go to jail for what they've done illegally, but the corporation itself can only be sanctioned, can't send the corporation to jail. But a corporation technically is a legal person, and that's why corporations can be sued and stuff. A corporate crime may result in the criminal conviction of the employee committing the offense, as well as the extension of vicarious liability to the owner and the corporation and management over that employee. Two tests for determining whether a corporation should be criminally liable. So we'll go through those. One is what they call respondeat superior, or the responsibility of the superior. A corporation may be held liable for the conduct of an employee who commits a crime within the scope of his or her employment, who possesses the intent to benefit the corporation. This extends vicarious liability to a corporation for the acts of employees, even when such acts are contrary to corporate policy. So if they're doing something criminal, but they're doing it and it's going to help, or they're doing it in furtherance of the corporation itself, the corporation can be held responsible for their actions. In the model penal code, criminal liability is imposed in those instances that the criminal conduct is authorized, requested, commanded, performed, or recklessly tolerated by the board of directors or by a high managerial official acting on behalf of the corporation within the scope of his or her office or employment. Then there's a case, Commonwealth v. Coxwara. A bar owner can be held vicariously liable for his bartender's sale of liquor to a minor. However, this vicarious liability cannot result in a prison sentence. Conviction was not reversed, but the punishment was modified to a fine and sanction rather than imprisonment. Another example, holding the owner of an automobile liable for traffic parking tickets issued to the car, despite the fact that the auto may not have been driven by the actual owner. So let's say a person is driving your car and they rack up traffic tickets, and when they get them, or parking tickets, and when they get the parking tickets, they ball them up and throw them away. Then you drive the car and park, and now you got hundreds of dollars worth of parking tickets. You are now on the hook for what they did because you let them borrow your car. And another situation is kind of on topic, but it's off topic. You're also held liable if you're driving someone else's car and that person hasn't done the proper things to keep their car inspection up to date. So once you get behind the motor vehicle, you have now assumed responsibility for the upkeep of the motor vehicle, even though the motor vehicle isn't yours. The motor vehicle is owned by someone else, but by getting behind the wheel of it and borrowing someone's car, if their tags ain't right, even though it's their tags and they had the responsibility to do it, you're now on the hook because you're operating the motor vehicle while it's in an illegal status. Most parking statutes consider the owner of the vehicle prima facie responsible, or the first face responsible for paying the ticket. This means that there is a presumption of liability unless you present evidence that you were not responsible. The burden is on the accused to prove that he or she was not responsible for the ticket. Then you have Commonwealth v. Rudensky. The Supreme Court exception to the due process requirement of prosecution's burden of proving guilt beyond reasonable doubt where the violation of law is a public welfare offense. Violation of traffic/parking regulations falls squarely within the proper classification of public welfare offenses. Under the public welfare doctrine, it is clear that prima facie strict liability may be imposed upon a registered owner of an illegally parked vehicle. The owner has the burden of coming forward with the evidence that someone else was operating his or her vehicle in order to rebut the inference that the registered owner is responsible for the vehicle's operation. So, another example, imposing responsibility on parents for the actions of their children. Parental responsibility laws. Laws against parents who abuse, neglect, or abandon their children or fail to ensure that their children attend school. An example, contributing to delinquency of a minor. Now, a minor who runs away is not a juvenile delinquent or delinquent minor. Delinquent is a minor that commits a crime, commits an act that would be a crime if they were an adult. So in other words, when you're contributing to the delinquency of a minor, you're contributing to the criminal actions of a minor. You're now essentially helping that minor commit crimes or facilitating the commission of crimes by a minor. That's what contributing to the delinquency of a minor means. It's not limited to parents. It requires some affirmative act on the part of an adult that aids, encourages, or causes the child's delinquent behavior. It is presumed that parents possess a duty to supervise their offspring, and that this type of statute would encourage parents to monitor and control their kids. Now, we'll go back to the example of parents being held liable for their children not attending school. That is very true. They're truancy laws. So you drop your kid off at school every day. You see them walk in, but as soon as you pull off, they leave. You're still on the hook. I know parents who have gotten in trouble and they got criminal records for truancy law violation because their kid won't go to school, or they drop them off and then they leave. That's a situation where they are that's vicarious, what we call vicarious liability. Okay, these statutes generally hold parents responsible for the failure to take responsible steps to prevent their children from engaging in serious or persistent criminal behavior. There are laws that hold adults liable for teenage drinking as well. It's called social host liability laws, and normally this is with civil law where a person can be sued, but sometimes there are also social host liability laws with crime and on the criminal side as well. It holds adults liable for providing liquor in their home to minors in the event that an accident or injury occurs. Teen party ordinances. It declares that it is criminal for an adult to host a party for minors at which alcohol is served. So what that means, and even with bartenders, you serve drink to some. If you're serving drinks to someone and you know they're drunk, and then they go out there and get in an accident and kill someone, it's highly as you can be found criminally liable or guilty as under the doctrine of vicarious liability. Williams v. Garcetti. Parents should be held liable for failure to exercise reasonable care to prevent a child's criminal behavior. This case stemmed from a challenge to the constitutionality of an addendum to a negligence statute that made it criminally negligent when a parent failed to exercise a duty in the responsible care, supervision, and protection and control over their minor child. There is a special relationship between parent and child, and accordingly places upon the parent a duty to exercise reasonable care, so to control his or her minor child as to prevent it from intentionally harming others or from conducting itself as to create an unreasonable risk of bodily harm. So I know some of that seems unfair, but when you have these children, you're responsible for their actions. So you have to take care. Now, of course, once again, this is one of those things that comes down to prosecutorial discretion. The prosecutors also have discretion in determining what they're going to prosecute. So that if it's a situation where a kid is still technically a minor, but they're old enough to kind of know what's going on and do stuff, like we talked about that situation where this parent is dropping the child off at the school, but then they drop the child off and then the child leaves. I've actually seen cases where where the prosecutor decides not to prosecute the person. So the thing about it is, a lot of times with truancy laws, and truancy is school attendance laws, that they're laws connected to mandated school attendance. So what happens is when let's say the students it's reported, the truancy is not usually reported by the cops. It's reported by school officials that are taking attendance. Like, this person hasn't been there, then they get a social worker involved, and then there's usually a school system social worker, and then they're the ones who get the charges taken out, and that's how it happens. So normally law enforcement isn't directly involved, so that's what gets them in court. But then it's up to the prosecutor to decide and look at the facts to determine whether they're actually going to prosecute this parent because their child is wilding and the parent's doing what they're supposed to do, but the child is leaving school. So that wraps up Chapter 6, where we talk about parties to crime and vicarious liability. So once again, as I told you before, my lectures are nothing more than a supplement to your reading and understanding this stuff. It starts with reading. You have to read, and then my lectures will help supplement. So that's why I give the lectures so it can bring everything in, and we can talk about what you've read and get a better understanding of it. And of course, I'm always available to answer questions if you have them anyway. So, all right, you guys take care. That's Chapter 6.